Okay, we'll go ahead and get started with this hearing. It should be noted that we had the debt chair. The chair would be myself. Also would be Supervisor Renee McClellan and Hardin County Recorder Lori Cadner. I'm going to go ahead and order at 1:01 p.m. I would entertain a motion to adopt the hearing procedures.
I'll make a motion to adopt the hearing procedures for today.
Motion by McClellan, second by Cadner. All in favor, say aye.
Aye.
Motion carries. The written that was filed August 21st, 2020, addressed to today, I write to formally object to the nomination by convention of Donald Primus, candidate for Hardin County Supervisor, according to Iowa Code 43.24, objections to nomination petitions or certificates of nomination. As the Hardin County Republicans recently conducted a similar convention, I have learned from the Secretary of State Pates's office that the rules and regulations are very clear and shall be followed. The bylaws of the individual non-governmental organization dictate the rules and order to nominate by convention. I have obtained those rules from the Secretary of State's office, and after review, I am confident those rules were not followed and thus disqualified Mr. Primus from being listed on the ballot. A particular violation in regards to the bylaws approved on what appears to be a typewriter-style document from nearly a decade failed to address the utilization of electronic means to conduct meetings in which a vote is held and recorded officially. The voting and quorum policy are clear to not include electronic means of participation or official voting. As shown in the supporting document labeled 1, Iowa Code Chapter 21.2 clearly identifies or defines a governmental body, what a governmental body means. The document labeled 2 explains Iowa Code Chapter 21.8 and how electronic meetings shall be utilized by governmental bodies. I will return to the process that Hardin County Republicans adhered to according to recorded and filed bylaws from 1993. Their bylaws make no mention of electronic meetings, electronic votes, nor any proxy voting. This is why the Republicans held their convention on August 11th, 2000, in person at the Central Iowa Juvenile Detention Center. At the convention, the Hardin County GOP followed those bylaws and conducted their convention accordingly, and have verified the process was followed. I'm citizen dated August 7th, 2020. No Democrats filed to run for the seat in the June primary, so Democrats had to reconvene their county convention to choose a nominee. The convention was held Tuesday via Zoom video conferencing. Patrick Gagnon, Vice Chair of the County Democrats Central Committee and Secretary of the Convention, said it was well attended with 51 delegates on the call. This quote is an admission that the nominee was elected utilizing electronic means, Zoom, by a non-governmental body. This body is not afforded the rights or privileges of governmental body when entitled to the use of electronic communications and voting that only pertain to true governmental entities granted those rights and privileges. The argument that the nominee should be allowed due to the emergency declaration by Governor Kim Reynolds is null and void due to the Hardin County Democratic Party not being an official governmental body. Per the Iowa Code, or correction, per the Iowa Secretary of State's office, this political body is not an official body and isn't subject to the emergency declaration that allows governmental bodies to conduct meetings and record votes on the official record. The preponderance of evidence indicating that the Hardin County Democrats violated their own bylaws was made clear on August 7th, 2020. Deviation of this non-governmental body, the Hardin County Democrats' own bylaws and rules because of an extenuating circumstances is not grounds for turning a blind eye to the rules adopted nearly a decade ago. The use of electronic meeting is the responsibility of every non-governmental entity to maintain bylaws and rules that adapt to the group's needs, their group's desires, and the evolution of technology in modern society. In this case, if, and then that sentence ends, the fact Vice Chair acknowledges that the convention circumvented the bylaws is the only evidence required by Iowa Code that Mr. Primus should be removed from the ballot according to process and procedure afforded by Iowa Code 43.24 sub 3 sub B. For the name Mark Seward, dated August 20, 2020, signed by Mark Seward.
Mr. Chair?
Yes.
Just a point of order. If you could identify for the record who else is personally present in the room.
Thank you. We have Mr. Primus.
My name is Shayla McCormley. I'm an attorney and here to support Mr. Primus.
Okay. County Attorney Darrell Meyer. Hardin County Auditor Jessica Lara. IT Extraordinaire Michael Pierce. Anyone else?
Is the objecting party?
The objecting party, Mr. Seward, is not present. I have not seen him as of yet.
Has he zoomed in?
Not
It's
what I
him
can
zoomed
tell.
Okay.
Would you have any way of telling?
If he typed in his own name, he would show up, but if he used a different name, he would not show. Well, he would show up, but we wouldn't know
So
who it could.
could the chair direct him to avail himself if he is participating by Zoom?
Yes, Mr. Seward, if you are attending this hearing by Zoom, would you please indicate by either typing something into the chat box, identifying yourself and what you're connected, what name or number you're connected under?
Is there any activity?
Moving on, so the document I just read that was filed on August 21st would be the information from the objector. And I don't believe there's any other evidence that's been presented to us regarding the claim.
So will the panel receive that written objection?
Yes. We have received it. Moving on.
To make a motion to approve the acceptance of it, or?
You can if you want, that's fine. It's kind of, it's kind of odd that the nature of the panel is, I guess if you want to conduct it by vote and name, roll call vote, that's fine. That's, I'd say the panel can choose to do it that way. Or if there's no objection, then
We're
you
not
can
going
just
to deny
receive it.
evidence. So,
Right.
sorry, folks, this is our first time doing this, so bear with us.
I
don't
mean,
see the
we've
need
all
to-
received
Yeah,
it.
we've received the
Yeah,
evidence.
received
And you might want to confirm if Mr. Primus received that as well.
Mr. Primus, did you receive the objection letter and the information that was provided
No,
regarding the objection?
no. You do not have a certified receipt with my name on it or a tracking number or my signature.
Well, I didn't send you anything. I'm just asking if you had an opportunity to
I haven't,
receive what was alleged.
I haven't seen it.
Okay. So now we'll move on to receipt of evidence from the nominee, which would be yourself.
Thank you for your time. At this time, referencing what we just talked about, I would move that the objection be overruled and dismissed on the grounds of 43.24, paragraph 2A. Objections have been filed. Notice shall be mailed within 72 hours by certified mail. Certified mail requires a signature. I don't have it. You don't have it. I move to dismiss.
You can take it under advisement.
Take it under advisement. Do you have any like, physical evidence or documents or anything?
Confirm
That,
the documents. That were
yeah,
submitted.
just to confirm the documents that you have submitted for this hearing.
I can confirm verbally that I've submitted the documents listed in number 6 on the agenda.
Okay. And I believe we've had an opportunity to review all those.
Yes.
I have. Okay. Thank you, Mr. Primus.
Chairman, may I raise one more issue?
Certainly.
We would raise a second motion to dismiss of this claim, requesting that the panel deny a hearing based on the fact that the objection that has been submitted does not offer any substantial compliance deficit with the way that this was presented to the auditor. And the fact is that the objection to Mr. Primus being on the ballot is based on internal works of the Democratic Party. He doesn't note any law that was not complied with. The nomination was timely, and the convention was held pursuant to Iowa Democratic Party and Hardin Democratic Party rules. And as the objector is not a member of that body, he is not able to raise an objection to the process. And also there's no jurisdiction of this committee to rule whether the internal process of the Democratic Party was run correctly. This panel must enforce the law, and there's nothing in Iowa code that says that the convention or the way the nomination was submitted was done incorrectly. And therefore we'd ask on its face for this panel to reject the objection.
Okay, thank you.
Thank you. Thank you.
Is there any other evidence that anyone needs to submit, either on behalf of the nominee or the objector? I'd entertain a motion to close evidence.
I make a motion to close the evidence.
Motion by McClellan,
Second.
second by Gander. Evidence is closed. Everybody on the panel has had an opportunity to review all the documents provided by both the nominee as well as the objector. And we can deliberate on that. If there's any concerns, or we can, now that we've had an opportunity to review everything, so we can go ahead and make a decision if we're to that point, or if you have any other questions or need to hear from anybody else.
I don't need to hear from anyone else.
A motion to what direction we want to go, or I know where I'm at.
Well, why don't you state where you're at and see if the others agree then.
Based on everything I've had an opportunity to review of the evidence submitted by the objector as well as the nominee, I'm in favor of overruling the objection.
I am too.
And it would be overruled.
Maybe just take a vote, like a roll call vote for that.
Okay. On the basis of, or for overruling the objection, McClellan,
Aye.
Gadner,
Aye.
McDaniel, aye. That's our decision. Well, you're the expert here.
Did you, well, just for the public, what were the reasons for, and you could all have 3 different reasons, but, just letting the public know why you
Okay.
voted that way.
Me personally, I was provided with the objection that was filed by Mr. Seward, as well as responses or evidence provided by the nominee dealing with the Iowa's Democratic bylaws, Hardin County's Democratic Party bylaws, multiple code sections that I reviewed. We're in a time where a lot of exceptions have been made. Not this was an exception, it's still a perfectly legal means of putting Mr. Primus on the ballot. There's no evidence of any law was violated or anything along those lines. The issue was also raised of a non-party member raising an issue with the bylaws, but there's a zero basis for that as well. So that's how I came to my position, or my decision.
That's pretty much what I found also. It's just, I think through the bylaws, again, it does allow for them to hold the Zoom meeting.
And mine
by
was
absentee.
reviewing the bylaws also and just knowing what kind of state we're in right now with the pandemic and what's being held countywide, statewide, and nationally. It just makes sense.
Okay.
And they followed their bylaws.
So Mr. Primus will be on the ballot.
Mr. Primus will be on the ballot.
Close the hearing then.
I'd entertain a motion to adjourn.
I move to adjourn.
I will second.
Motion by Kettner, second by McClellan. We are adjourned. Thank you.
Thank you.